All right, here's a fun game. Try to come up with a number of current cases in which the state of Idaho is being sued over the laws passed, I don't know, let's say within the last 5 years. Set aside the most recent lawsuit over the block sale of the Idaho Transportation Department property. There's a handful centered on Idaho's abortion bans, including the abortion trafficking lawsuit we already talked about this week. And then there's another handful focused on restrictive transgender laws. From the very first transgender athlete law, which bans trans girls and women from competing on women's teams, which is still tied up in courts, to the lawsuit that was before the Ninth Circuit Court of Appeals today, Roe versus Critchfield. This case is over Idaho's bathroom bill, Senate Bill 1100. Signed into law last March, and it says students in Idaho schools have to use the bathroom and locker room, which coincides with their birth gender, not their gender identity. It went into effect in July, but after a lawsuit was filed 5 days later on behalf of a transgender junior high school student, a temporary restraining order was issued in August with the hope of blocking its enforcement while the law gets decided in court. Well, that injunction was denied by a federal court, and that decision for that denial, that was appealed to the Ninth Circuit, who in November temporarily blocked it again while they decide whether they will affirm the lower court's decision. So that brings us to today, whether or not to uphold that denial or issue a preliminary injunction. But in deciding that, the three judges got to hear both sides lay out the crux of their overall case. At issue, the plaintiffs argue Idaho's bathroom bill violates equal protection clause of the 14th Amendment, and it also violates Title IX. So Title IX, which was written in 1972, and as Judge Bennett pointed out today, seems to be written referring to sex assigned at birth. It allows for separate and comparable facilities on the basis of sex. So is there discrimination in Idaho's bathroom bill based on sex? Yes, says the plaintiff's attorney from Lambda Legal, against transgender students. Peter Wren said differences in treatment that injure protected individuals, well, that's the definition of discrimination. Wren says Idaho's argument can be separated into two buckets. One, it's a safety or a privacy issue. They have to exclude transgender students because there's no other way to prevent bodily exposure. But as Wren pointed out, Idaho has had 8 years of inclusive policies in about 25% of the state's school districts. And there's no evidence it has ever been a problem. And if there is a real concern with that, he said the solutions would be, well, just close the bathroom stall doors or the locker room shower curtains.
So that leaves the only other argument that the government has available to it, which is about the mere presence of a transgender student. We're talking about transgender students who are using the facilities for the same ordinary and permissible purposes as other students. The concern that cisgender students will engage in an elaborate charade of pretending to be transgender in order to access facilities where they're not supposed to be. And Idaho already takes steps to prevent that. So Boise School District, for example, for the last 8 years has had a policy involving school counselors and written gender support plans to ensure that requests are actually legitimate.
So according to Wren, school resource officers confirmed they already have what they need to handle such situations. And SB 1100, well, adds nothing to that. So on the state side, their attorney, Aaron Hawley with Alliance Defending Freedom, quoted the late Supreme Court Justice Ruth Bader Ginsburg saying, Title IX establishes separate spaces to disrobe, to sleep, and to perform personal bodily functions. Not only is that separation allowed, but necessary. They claim the law does not violate Title IX because while protecting students' privacy, it allows for accommodations for anyone who doesn't feel comfortable using the boys' and girls' spaces. For example, they can ask to use a staff or a nurse's office bathroom. Okay, so as for the Equal Protection Clause part of this, the state contends the law differentiates based on sex, not on transgender status. After one of the judges asked, doesn't this law only impact transgender students, though? Hawley said in order for there to be a violation, well, it has to be proven there was intent of ill will or hostility.
That's why disparate impact under the Equal Protection Clause requires animus. That animus under the district court's factual findings is lacking here. What Idaho did was do its best.
I can recite to you several things that would lead to the conclusion that some of this was pretextual. For example, Senator Chris Trakel attended a school board meeting in 2023 where he said, you under Idaho law are required to maintain the morals and the health of all students. And thereafter, Senator Cindy Carlson wrote that we need to send the message that we want to educate the kids of Idaho, not indoctrinate them with this garbage. and the fact that SB 1100 itself was drafted by the Idaho Family Policy Center, whose mission is to promote God-honoring public policy and biblical truths in sexuality and gender.
Judge Wardlaw brought receipts, as you can see, right in front of her with the briefs. Well, Holly went on to say many of those things that she was quoting, well, they were things that were said outside of the legislative context. And the lower court, in its ruling back in October, said the legislature had, quote, no animus. So there you go. Well, this decision is just whether or not to allow the enforcement of the law while the lawsuit plays out. They're not trying to decide whether the law is legal at this point. They're going to see what the lower courts decide with that. So we will wait and see what the Ninth Circuit decides on whether this law goes into effect now or there is an injunction.